Hello everyone. Am I audible to all?
Yes, yes. I would like to request to all of you that you should mute because there is some echo. So I request to all of you to mute. Please.
Okay. Good morning everyone. First of all, I would like to welcome everyone for taking out their valuable time for attending today's seminar on basics of court appearance. So today's seminar will be taken up by Ms. Dr. Nityanand Singh, who is before you. This seminar will be Mr. Singh is a member of Honorable Supreme Court of India and fellow member of Institute of Company Secretaries of India. He has secured a doctorate in law. Mr. Singh is an advocate by profession and practicing at Honorable Supreme Court of India. He has extensive experience of more than 20 years in litigations. Mr. Singh is a partner and founder of an international law firm, Nux and Partners, Advocates and Solicitors. Nux and Partners has been operating as a corporate firm in retail concept and currently handling litigation matters in more than 500 districts in India and abroad. Mr. Singh is also running an NGO with the name and style of Vidya Vijay Foundation and serving the poor and needy people for upliftment of their education, social and living standard. The name Vidya Vijay came from the name of his parents of Mr. Singh. The first word is the name of his mother, Mrs. Vidyadhari Devi, and the second name has came from the name of his father, Dr. Vijay Narayan Singh. Mr. Singh is a visiting faculty of IIM, that is Indian Institute of Management, ICSI, Institute of Company Secretaries of India, ICAI, Institute of Chartered Accountants of India, and various other law colleges and business schools in India. Mr. Singh is also socially and politically active and contested the elections of Legislative Assembly at Delhi twice. Now, Mr. Singh is before you to give you a brief on the topic of basics of corporate appearance. Now, I'm passing on to Mr. Singh. Please, sir.
Thank you, Ms. Priti, and thank you to all of you and welcome to all of you to join this, the basics of the court appearances. First of all, I would like to tell that our session would be approximately 45 to 50 minutes, and last 5-10 minutes is for the question answer session. So I am going to tell because I have personally feel that most of the students are the young professionals came into the court and they are not very well aware from what is the basics, how to appear, how to address to the court, and how to take the relief from the courts. Therefore, they feel embarrassed. And sometimes I personally feel that at certain times the Honorable Judge feel annoyed by the person who is appearing before the court, even though they are the professionals and just qualified. So therefore, I personally feel that being a professional to guide our young professional so that how they can appear before the court and what should be the behavior and how to address. Therefore, I have started this program to acquaint the court appearances. That is the very basic. I am going to touch on the very basic things. It is very, very much required to appear before the court. So, first of all, I would like to say that once you are the professional and you are working with associates or senior associates in any office, and your senior asks you to go and appear before the court, then the first and foremost thing that you have to look into the file, what the file your senior is giving to you. And once you receive the file, then first of all, you should go through that what is the contents of the file and what is going to happen tomorrow in the court. Then once you receive the file, then first of all, you have to check what is the cause list of that particular matter and where is matter is listed and what is the name of the court. and what is the item number. That is very, very important, because once you are going to the court, then you should be very well aware what you have to the court and what is the item number and where it is listed. This is the first and foremost thing. Once you check all those things, then you should know what is the going to be happen on the next date, next tomorrow, what is going to be happen in this file, for what purpose the matter is listed. If the matter is not in the admission stage, then you have to look what is the prior date of order. Suppose if it is matter is listed tomorrow on 12th and you are going to appear tomorrow, then you have to look into the matter that what is the previous date of hearing and what the order has been passed by the honorable judges in this particular matter, and for what purpose this matter has been fixed tomorrow. Once you will go to the order, you should check then what is the order and what is the purpose. Then you will be aware, yes, the matter is going to be listed for that purpose. And once you are not able to understand that what is the purpose listed for tomorrow, then you should ask your senior or immediate senior, or who is your senior and to whom you are reporting. Once you are not able to understand, then first of all you should ask your senior then what is for what purpose this matter is listed. Once you are not able to understand, once you are understand, then read the file properly. Once you read the file properly, once you go through the contents, then you are ready to appear before the court. Then once you are going to appear before the court tomorrow in the morning, then what is the basic things you require to do? First of all, you have to be very well dressed. There are the certain prescribed uniform as per the Advocate Act. Then you have, once you are appearing before the court, then you have to be in the proper uniform. Uniform is prescribed that you have to be in the white shirt, black coat, black trouser, along with the band or necktie. Once you are appearing before the court and you are not in the proper uniform, then it is a very difficult situations. Once you are appearing before the court will say, yes, Mr. Counsel, you are not in the uniform. Why you will here? Who are you? I personally feel certain times the court asks the questions, yes, you didn't looks like a counsel. Why I will hear you? You are not in the proper uniform. You are not having the proper band. If you are appearing before the High Court or Supreme Court or any other court, and if the gown is required, then you have to have a gown as well. This dress code is a very much compulsory, because once you are appearing before the court and you are not in the proper uniform and you just started speaking, but honorable judges said, yes, Mr. Counsel, you are not in the proper uniform, I will not hear you, then you will feel very embarrassed. And whatever you remember and whatever you are going to argue, that you will forget all those things. So to avoid all those complications, you have to have a proper uniform. This should be a very basic thing, but that is a very much required. Unless and until you will be in the proper uniform, the court will not hear you. You should keep in mind. And once you are in the uniform, it should be very neat and clean. Once you are, it is a white shirt, it should be properly ironed. It should be, once you are having the coat should be in the proper ironed. And what are the band? Once you are appearing with band, then the band should be the white and it should be very neat and clean. Certain times I personally feel that the advocates appearing before the court in the not proper band. Sometimes it is not very ironed. Then also the honorable judges doesn't feel looks, because once you are an advocate appearing before the court, prima facie, it should be very good that prima facie it looks that yes, you are the excellent one. Then the court will hear you properly. Otherwise, once there is something which doesn't looks good, even someone is appearing before me and he doesn't looks good, he is not with the proper dress, then it's come into my mind that yes, the counsel who is appearing is not proper dress, then how he can address and how he can protect this client. So this should be avoided. You should be in the proper, neat and clean dress. So this is the second issue. And thereafter, we will come on the point, that is the third point, that is on the time. Once you are appearing before the court, then you have to be very, very particular about the timing. Normally, in the lower court, time is at 10 o'clock. And in High Court and Supreme Court, time is at 10:30. Once I am talking about in respect of Delhi. It may be vary, time may be vary from different courts in different cities. Therefore, whatever the time, you should be aware that at what time court on the chair, then you should be very well aware from time, and you should be reached before the time. Suppose if you are going to the district court and the time is 10 o'clock, then you should reach in the court at 9:50 or 9:55 before 10 o'clock. Because I personally feel that once the honorable judges on the chair and started the matter, suppose if your matter is the very first call and you are not appearing before the court, then it may be possible that the warrant may be issued against. If it is a criminal matter, then the warrant may be issued against your client. And once you are appearing before the court, 10:05, and you will heard that yes, non-bailable warrant has been issued against your client, then it is very, very difficult situation. You will not able to answer your senior as well as your client. Because once you will go and say to your senior that, sir, today we did not appear before the court on time, therefore the court has issued non-bailable warrant against our client, then what would be the impression of your senior, and what the impression of your senior goes to the client, and what the client will think that the learned counsel is not appearing, therefore the warrant has been issued. This is the very badly impacted your client. So you should be very well aware about the timing, and you should reach on time. You should not delay a single minute, because single minute delay causes you a great hardship for you as well as your client. Therefore, you should reach on time, and further you will go ahead once you will reach on the time in the court, and once you are reaching in the court in time and entering in the court, once you reach in the time and enter into the court, then you should how to behave with the court. Once you are in the courtroom that you have behavior, your behavior has to be as a professional behavior. Means once you are sitting on the chair, your mobile should be on the vibration. Your mobile should not ring. Sometimes I feel that the person who is appearing or advocate who is the freshers appearing before the court, they forget to vibrate their mobile, then it is also causes a great hardship. Sometimes in the Honorable High Court and Supreme Courts, your mobile may be kept for an entire day. Only because of that, your mobile is ring in the court. Therefore, this is also a courtesy to appear before the court, that you should always keep your mobile on the vibration. And once you are sitting in the chair, because the learned judges are in front of you and you are sitting on the chair and waiting for your turn, then you should also behave professionally, that you should not do something which embarrass to the court. Therefore, you should keep in mind that you should, even though your matter is not coming, but you should properly watch to the court. Watch to the court in the sense you should try to understand then what is the mindset of the honorable judge at that particular time in that particular matter, or there are the different matters are going on, then how the learned judges are behaving. Sometimes very liberal, sometimes very strict. So you have to face different type of and mindset of the judges. Then you have to, once you are appearing in the court and sitting in the chair, then you should watch very carefully how the learned judges are behaving, because once your matter will come, then how to react, how to address to the court, that you should get the relief. Because once you are representing your client, your representation up to the 100%, so that you can get relief. Once you are not getting the relief, then it is very difficult. The person will give you the case. So being a professional, being an advocate, your behavior should be 100% professional. Once you are sitting before the honorable judges, then you have to behave professionally. There should be no negative remarks in the mind of the judge. Because taking an example, once you are sitting in the chair and you are behaving something different, means you are playing with the mobile, or you are doing something different, or your behavior is not up to the mark, then don't think that the honorable judges sitting in front of you is not observing you. They are observing you, and very much observe you, that once your turn will come, then the learned judge will invite you on you, that you should not have such behavior, or once you are sitting in the courtroom, then you should behave professionally. Therefore, you should avoid such type of the activities which invite to the honorable judge, because once you will appear, then they will react on that time. They will not react earlier, it may be possible, but that then they will react, and whatever the relief you are asking for, certainly you are not going to get a relief for the relief you required. Therefore, you should, this is the very basic thing I am touching upon, but this is my practical experiences. Therefore, I would like to share with you that you should be very cautious about all those things. And thereafter, once your turn will come to address the argument, then you are already aware about all those things. Your file should be the properly paginated. Paginated in the sense, there should be some proper pagination, 1, 2, 3, 4, and 5. And whatever the you are going to address to the court, you should be very well aware what are the contents of that before going to address. Once you are appearing before the court, then you should be aware there are the two-sided. One side is the petitioner side, one side, another side is the respondent side. Whether you are the petitioner or respondent, you should also keep in mind that whether you have to stand on the petitioner side or on the respondent side. It is also very important, because once there is a petitioner side, the judges, honorable judges, simply say you are appearing on behalf of the petitioner. And once you are appearing on the respondent side, then it is came into the mind of the honorable judges that you are appearing on the respondent. But if it is vice versa, you are standing. Suppose in the left side there is a side for the petitioner, in the right side there is a side for the respondent. And being a petitioner, you are appearing in the right side, on the side of the respondent, then it is also an embarrassing situation that honorable court will ask you that whether you are the respondent. Then you will say, no, no, I am the petitioner. Then the court will say, why you are standing there? Come here. Then it also creates sometimes embarrassing situation. To avoid these situations, you should be well aware that whether you are the petitioner or respondent, whether you have to stand on the left-hand side or in the right-hand side. You should very well aware from this fact. And if you are the petitioner, then the petitioner started arguing the matter first. And once you are appearing on behalf of the respondent, then you should not started arguing first, because it is a chance of the petitioner, case of the petitioner or complainant. The complainant or petitioner have a first right to say something. Once you are moving any applications and you are the applicant, then you have to start your argument first. And once you are appearing for the respondent or non-applicant, then you should not start speaking something. It is the basic courtesy of the court. These points should be always be mind. And once you are addressing to the court, these should be very, very well carefully observed. Once you are appearing on behalf of the petitioner and you start, once your number is called and you appear before the court, then how to address to the court, that is also very important. You say something, my lord, or your ladyship, or my lady. Even one PIL has been filed before the Honorable Supreme Court, then why you should address to my lord? Because my lord means something in God. One PIL has been filed before the Supreme Court, then it is observation of the Supreme Court that it is not mandatory that you should say my lord or my lady or your ladyship, yeah, or your lordship. Even though there should be some respectable words, if you address to the court, sir or madam, then that is also sufficient. But the prevalent practice before the honorable courts, that most of the, even the senior advocates also address to the court with my lord or my lady or your lordship or your ladyship. Once you are the appearing, then you should address to the court. Once your item number is called, suppose your item number is 12, and the reader or court master has called item number 12, immediately you should stand up and say, yes, my lord. Once you will say, yes, my lord, it prima facie shows that, yes, you are attentive. And immediately once the matter has been called, you say, yes, my lord. The court, it come into the mind of the court, yes, someone is appearing either on behalf of the petitioner or on behalf of the respondent. You should not just, you are sitting in the chair and coming slowly and slowly before the court. This should not be done. You should avoid such practice. You should be very attentive. Once your item is called, then immediately stand up and say, yes, my lord. One basic courtesy of the court as well. Once the honorable judges coming on the chair, then once you are sitting in front of the chair, then you should stand up. You should be never be sit on the chair when the honorable judge is coming on the chair. This is also one of the court courtesy. Once the honorable judges come on the chair, they will pay respect you by folded hand, namaskar. Once the honorable judge will address to the gathering and with folded hand, namaskar, then you should also reciprocate in the same manner with bending head, yes, namaskar. So this is one of the basic court courtesy, that once the honorable judge is coming on the chair, then you should not sit on the chair. You should immediately stand up. And once you are sitting in the chair and due to some reason the honorable judge is standing from the chair, then you should also stand up. This is one of the basic courtesy, and each and every has to be followed before the courts. Just I am touching all those points because the juniors or the person who is appearing before the court is not very well aware from all those facts. And once they are not very well aware from these facts, they feel sometimes very embarrassed. So to avoid all those embarrassment, to nervousness, to hesitation, I am only touching the basic things. So therefore, all those things will be remembered. Once you have started arguing the matter on any subject matter, Therefore, it should be basic point you should need to think that what are going to argue. It should be properly paginated. It should be properly flag marked. Suppose if you want to address to the court, my lord, this is our fact. Certainly, court will ask where it is written. Then you should not started turning up the pages. This is a bad practice. You should mark with flag your page properly. Once your file is properly flagged, then immediately you will answer, yes, my lord, this is on the page number so and so. It is on page number 17, yeah, page number 16. Kindly see. And what is the relevant portion you are addressing to the argument, that you should be highlighted properly so that you can read that particular paras only. Suppose page number 17 at the bottom or para number 2 or 3. Then you should address to the court, yes, my lord, this is the page number 17, para number 2 and 3. Kindly, may with the permission, you should ask, with the lordship permission, may I read? If the honorable court say yes, then you should read, and you should apprise to the court that I am addressing from this point. And once there is a prayer clause, the prayer clause should be the separate on the separate page. You should never mix up the prayer with the another contents of the pages, because the prayer clause is very, very important. In the entire file, the only prayer clause is going to be observed by the honorable judges. What the prayer asked for. So prayer should be the entirely different page. This should be always be keep in mind, because once it is on the another page mixing with the another contents, then it is very difficult to corroborate. Because suppose if it is a prayer clause in the first page, 1 and 2 page paras of the prayer clause in the first page, and in second clause, third and fourth para in the second page, then it is a very difficult situation to analyze to the judges. That first of all they will turn first page, then they will turn second page. It is an embarrassing situation. It is a very difficult situation put to the honorable judges as well, to go through the prayer clause in the first and second pages. So once you are, because this is the skills of the drafting, and once I will take the session for the drafting skills, then I will go into the detail and tell me all those things. But once you are addressing to the court, then you should be very precise, because the time is very important, very, very important. What is the time given? You have to address to the court in the very limited time. Suppose time is allotted, because in the court, most in the quoted courts, 50 to 60 cases minimum. Once I am talking about the minimum 50 to 60 cases are listed every day. Sometimes before the learned MM, it cases goes to more than 100. So honorable judges, time is the very short, very limited time. Whatever you want to say, you have to say in the very limited time, that is within 2 to 5 minutes. 5 minutes is more, but hardly you have to address to the court, and you have to the point within 2 or 3 minutes. Once you are addressing to the court to the point within 2-3 minutes, that is sufficient. And accordingly, you will receive the favorable order. And once you are addressing to the court that is not very much relevant, and it is taking too much time, then it is also give the bad impression to the court. Then you should be very precise, to the point. You should address the argument. And once you have addressed the argument, very precise, properly flagged, and you have tell to the court each and everything, then you should wait at the another party, and then the another party will address the argument. You should not mix up the things. Means suppose once you are addressing the argument, the respondent keep mum. Respondent will not interfere whatever you are addressing and arguing the matter. Once he is interfering in between, then you can say to the court, my lord, once I am addressing the argument, kindly direct to the respondent or opposite party to not interfere in between, because he has the turn. Once he has the turn, his turn will come. He can address the argument. I will not interrupt. So you can address, you can say to the court, and certainly court will direct, yes, Mr. Counsel, please have a patience. Give the time. Once you will address the argument, then your turn will come. Then you can address the argument. And once you have addressed the argument, the turn will come of the respondent or opposite party, and he will address to the argument. Then you should not interfere in between unless and until there is some urgency to interfere. You should note down all those contents, what the respondent is addressing. Once you have addressed, your address is complete. Then the respondent will address to the argument. You should not interrupt in between, and you should note in the writing what the point he is arguing the matter, at what point he is arguing the matter. Once you have noted all those points, then once his argument will be finished, then you should start arguing on that matter, because another opportunity you have. Then you should address the argument in detail. My lord, on this point, I have addressed this argument, but my learned friend, because once you are appearing in the court, then you should also respect to the opposite counsel as well, because the learned counsels, all the learned counsels are brothers. This is the very basic concept. They fight before the court, but they all are the brothers. So you should always have a same respect for the learned counsel, opposite counsel, because the opposite counsel also will give the same respect to you, and you should also give the same respect to him. So this is the basic court courtesy. Once you are saying anything that the opposite counsel says something, then you should always use the words, yes, my learned friend or my learned counsel has addressed this issue on this point, on this point. Therefore, I will revert on this point. It may be you can say that my learned friend is not actually correct and is not addressing to the court up to the mark. He is trying to mislead to the court. Whatever you want to say, but whatever you are addressing, it has to be with respectful language. So you should be always be very cautious, because once he is the opposite counsel, then you should not behave like that. And something also, that once you are addressing to the court, then you should address to the court. You should not fight to each other. Suppose if the opposite counsel says something, then you should not say anything to the opposite counsel, because it is not one-to-one fight between the counsel, but you want to take relief, then you have to have address to only to the court. And once the opposite counsel is saying something to you, then you can simply say, yes, my learned friend, you should not, there should be no fighting between us. Whatever you want to say, you can address to the court. Don't say anything to me. There is nothing is personal. So whatever you want to address to the court. And in the same behavior, you should also behave like that. Yes, you should not fight to the opposite counsel. You should not say anything to the counsel. You should, whatever you want to say, you should address to the court. And one thing, that being an advocate, we should always protect your client. It is our primary responsibility and duties to protect our client. That yes, my client is always right. It is not to decide that who is right, who is wrong. It is once he is my client, he is always right. It is our duty to protect your client in all respect, whether he may be right, may be wrong. It is the duty of the honorable judge to decide who is right, who is wrong. It is not our duty. So never think that the person who is coming to you is right or wrong. But once he is coming to you and you are appearing on behalf of your client is always right. And you should address the argument in such a way to convince to the court that yes, my client is always right. It is not the duty of the learned advocate to decide who is right, who is wrong, because the judge is the appropriate authority, honorable judge, to decide who is right, who is wrong. Therefore, once you have addressed the argument, opposite party has also addressed the argument, then the court will decide the matter. It may be the court will immediately pass an order, or once it is a final argument, then the matter will be further reserved for order. But once there are the two natures of the cases, civil nature of the cases and criminal nature of the cases. So once you are appearing in the civil nature cases, the client is not mandatorily required to appear before the court. But once you are appearing in the criminal nature cases, then the client is required to appear before the court in each and every dates. Therefore, before entering into the court, you should be also make sure that whether your client is coming to the court or not. Once your client in the criminal case is not coming to the court, then you should also prepare exemption applications. Exemption applications. Exemption application shows that yes, my client is not coming due to maybe the reason, maybe he is not well, maybe he is out of station, maybe he is attending the marriage, or reason may be anything, or he is out of station, or he has gone somewhere, he has gone to the school, or his wife or his son is not well. Maybe the reason anything, but once your client is not coming to the court, then you should prepare an exemption applications. That is mandatory. Once you are not preparing exemption applications and you are not moving an applications, then court will pass an order, bailable, non-bailable warrant against you. Therefore, you should be very well prepared to appear before the court. You should not go to the court in a haphazard manner, because this embarrassing situation is there. You should avoid the embarrassing situations. You should be well prepared. You should do your homework. You should exercise very properly. Once you are moving an applications, then there should be the proper ticket, court fee. You have to pay the court fee. It should be properly stamped. Proper court fee has to be paid on that particular application. You should always keep in mind that once you are moving the applications, there should be some proper contents, name of the party, name of the court, applications, regions, and it should be signed by the council. And it should be there should be some court fee. Once it is not properly court fee has been affixed, then again the court will reprimand you. Yes, Mr. Counsel, what are you doing? At least you should do something, that you should affix certain papers, certain court fee stamps. Then this is also a very embarrassing situation. So you should avoid all these situations. You should do the proper homework. And once you are addressing to the court and matter is over, once the matter is over, then you should always say to the court, I am obliged, highly obliged. This word should be used and bend your head. Yes, my lord, like this. Yes, my lord, I am highly obliged. Even though the matter is maybe decided in your favor, not in favor, even the order has been passed against you, but even though you should basic courtesy follow the court, that yes, otherwise you should not be invited and run away from the court, behaving like this, being angry, that yes, court has passed an order against me. This is wrong. No, because you are the professional. You are appearing in the professional capacity. You are protecting your client. Maybe appear for one client today and maybe appear for the another client today before the same court. The court will observe you that you become involved on that particular day, because regularly you have to appear before the court. Then your behavior should always be a professional behavior. You should never be involved. You should never be irritated. Even in the argument session, you should also not be irritated. You should address to the court professionally. Sometimes my experience says that it sometimes also happens that the opposite party always try to irritate you, interrupt you, only because of that you should say something wrong. and you should forget whatever you want to address to the court. Therefore, you should have a cool, you should have a calm, and you should address to the court without any irritation, without being angry, and even after the interruption of the opposite counsel, you should not be annoyed, you should not be irritated. Because once you will annoyed, you will be irritated, whatever you want to address to the court, want to say something in the court in your favor, and you can take the order in your favor, but only because of that irritation, you are not able to do, or you are not able to say something which you want to say. Therefore, your behavior should be always a professional behavior. And once you are leaving to the court, then your behavior should be always a professional behavior. So there should be some proper preparations. And suppose if it is a bail matter and bail has been granted by the court and you are appearing before the court, then you should properly fill all those bail bonds, forms, whatever the necessary requirements, that you should annex all those documents. What is the safety is required. Once the safety is required, then you should complete. I would like to say that whatever the formality you have to do complete your formality before entering into the court. You should fill the form, you should affix the photographs, you should annex the surety and identity proof of the surety. All those things you have to do. You have to prepare. You have to do your homework. Then you should enter into the court, because sometimes clients say that advocate will go and hardly say something in 1 or 2 minutes, and they are charging after lakhs of rupees. Why they are charging? Because lakhs of rupees they are charging only because of that they are doing their homework at least a day or 2 days, 3 days. It may be spent 2-3 days to prepare and address the argument for 2 or 3 minutes. So therefore, your entire homework has to reflect before the court in 2-3 minutes, because you don't have a very much time. You don't have a time, and you don't have to address the arguments in the very lengthy manner. You should be very short and sweet. You should cut your argument. You should address your argument in the very professional manner. So therefore, whatever the homework you have done, that homework should be up to the mark, and it should be reflected before the court. Yes, there are the certain homework has been done by the learned counsel. It will be always a pleasure to the court that the court will listen you properly, court will hear you, and certainly the court always pass an order in your favor once your exercise is up to the mark. It may be possible certain times, it may be possible that you are knowing that my client is wrong. It may be possible that my client may lose this case, but it is not always correct that who will lose, who will win the case, because my experience says it is all about depends how to address the argument, how to present the matter. Presentation skill is very, very much important. Once you are talking about the presentation skills, then communication, when I was missing the very important thing, that is the communications. Communication skill is also very, very important. Once you are communicating in English, because once you are appearing before the, especially I am talking about the experiences in Delhi courts. Either you are maybe the district court, either maybe in the high court, either maybe in the Supreme Court. The language of the high court and Supreme Court is English, and that is the mandatory that you have to address the arguments in the English only. Then you have to have a command on the language. Once you don't have a command on the language, then it is a very embarrassing situation to appear before the high court and Supreme Court. So once you are not very well versed with the language and you want to be a good advocate, then you have to have by hooks and crooks. You have to learn that skills. It is by mandatory or by choice. Once you want to be an advocate, then you have to have the command and the language. Language means English language, because everything has to be adopted English. Everything you have to address to the court in English. Because sometimes it is maybe my personal view, but sometimes I feel that the person who is addressing the arguments in the very excellent communication skills in English, the judges hear you very carefully and listen very carefully. And sometimes you are whatever the saying 100% correct in Hindi, it sometimes is not that much of the effective in the English language. Therefore, once you are not very versed with the language, then you have to learn something, then you have to do exercise, then you have to do hard work, how it can be learned, especially once you are in the wants to start your practice in Delhi, then you have to have the command and the language, because once you will go to interview somewhere in the law firms or representing the matter before the courts, then it is a very mandatory requirement that once you have to address the argument in English. Therefore, you have to do exercise in the communication skills as well. So, I would like to say that whatever I have covered, cover the entire basic things: how to appear, how to present the matter, how to be on the time, how to be communicative. So, entire skills are required. That is the very, very basic things I touch upon, so that the young professional appear before the court, go to the court, and not feel embarrassed, because sometimes because sometimes I used to see that the young advocates appearing before the court, and court reprimand that, yes, Mr. Counsel, you don't know anything. How you come to the court? At least you should read something. You should avoid such type of the remarks from the honorable judges. You should be very well aware from the fact. You should properly flag your file, and you should also prepare your arguments in brief. Suppose if your file contains 70 pages, 100 pages, but once you are going to argue the matter, then there should be the one pager brief. You should write something specifically that this page number, this points, this page number, this point, this page number, this point. A one pager, because most of the senior advocates appearing before the court always have their one pager. In one page, they have the entire story of the case. So before going to address the argument, you have to prepare your one pager as well. So this is all about the basics of the court appearances. Now the question answer sessions. Anyone have their questions, anyone want to ask something, then certainly they can ask one by one. Please.
Please.
Yes, please. Miss Lakshmi.
ठीक हो मास्टर पर ठीक है.
Yes, any questions from the anyone want to ask? From the learned listener. Please ask something. Everything is clear to all of you? Yes, Mr. Ajay. Mr. Ajay, I am audible?
Yes, sir. Sir.
If you want to ask anything. Yes.
Just give me, sir, 5 minutes. I am on the way.
No issue.
After
No,
some time, I will ask.
no issue. No issue. No, no, please.
Yes.
Anyone, please? मान सिंह जी,
नमस्कार सर।
नमस्कार नमस्कार।
सॉरी थोड़ा लेट हो गया, अभी ऑडियो आ नहीं रहा था, अब आवाज आने लग गई सर आपकी।
No issue. No issue. Want to anyone? Yes, Mr. Deepak.
Good morning, sir.
Good morning. Good morning. Everything is clear to you, or you want to ask something?
Sir, when you are a fresh, then there are very difficulties related to arranging of files.
Yes, yes.
Can you suggest something when a new case come to you? How that file must be prepared?
Yes, yes. Please. Very good question.
Annexer, there is a certain standards of annexer that so and so page this annexer will be in particular sequence. It must be as an annexer.
Yes, 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 yes.
कोई भी कह सके
Criminal
नहीं
procedure
और
cases.
ठीक है ना?
Yes, certainly. I will answer. Learned friend, mute because there is a echo in the system. Yes. Suppose I'm taking an example. There is a echo. Man Singh ji, please. Yes. Suppose I'm taking an example. Suppose real estate clients approach to you and he has invested approximately 10 lakh rupees in the real estate project. And approaching you that neither the builder is giving the possession nor refunding the amount. And you are the counsel, Mr. Deepak. Then you should always keep in mind then what is the very first thing that he has filled the applications form. Then there is some receipts, paid the amount. Then thereafter the allotment letter has been issued. Thereafter the agreement to sale has been concluded and offer of the possession and all those things. So your documents should be properly annexed one by one, means from the date of the incidents. Suppose the date of incidents we are booking first booking day in the November 2021. Then thereafter the receipts, whatever the sequence from November 2021 onwards. Then your pages should be accordingly paginated. And once you are addressing to the court, then you should say, yes, my lord, you should flag your page, particular page, that yes, this page, this is the application. You should, while you are addressing to the court, you can say, my lord, this is an application for the registration which we have booked the flat in the year 2021, November 2021. Thereafter, kindly see page number so and so. There is a allotment letter has been issued. Thereafter, you can say, yes, my lord, in the thereafter on page number so and so, this is agreement to sell. And as per this agreement to sell, para so and so, this is the possession clause that he has to hand over the possession within 3 years or 4 years. And he has not handed over the possession. You should particularly highlight that particular portion of the possession. My lord, para this, page number this, para this. So you should address accordingly. And it has to be properly paginated. Therefore, it is very easy to you and very easy to the court as well to look into the matter. And once it is not paginated properly, not flagged properly, then court will ask you, yes, Mr. Counsel, when you have booked the flat, then you will start turning up the pages. That is an embarrassing situation. You should be well prepared. You should be flagged properly. You should be note, one page note. This is the procedure. This is the, you can say, preparing of the file. File should be properly paginated. Then you are able to address within a short period of time, hardly 2 to 3 minutes. You will answer all those queries. And once the honorable judge is asking something, then certainly you should ask to the point, answer to the point. Whatever the point learned judge is asking, you should only reply to those points. Don't try to go either and either. Only to the point you should answer. Am I clear?
Yes, sir.
Anything else, please?
Sir, one more question.
Yes.
Sir, sometimes there are questions other than the file we carry, right? So
Yes.
as a fresher lawyer, generally we don't have the answer. Then how to address that? How to deal with such type of question by honorable court? What we can say in that situation?
Once you are not aware from this fact and honorable judge asks something, then you should simply say that, yes, my lord, I will ask my client, I will take the instructions from my client, then I will say something. Kindly give me some time, maybe 2 or 3 days, or maybe adjourn the matter. Certainly we'll go and update on that particular issue, and once being updated, I will come to the court and assist to the honorable court. In this respect, my lord, particularly it's the once in respect of this question answer. You can say like this.
Okay, sir. Thank you, sir.
Most welcome. Yes, anyone, please. If there is no question, then you should end up the session. Now time is approximately 12:30.
Sir, as I am a beginner, so how
Yes.
I can start appearance before the court, before the any judicial authority. So as a beginner, what should be the remove of our hesitation, and how I start my own self?
Yes. That's why I
Yes.
covered this basics of the court appearances. I tell in the entire detail that what should be the required once you are the very beginner and the fresher. Once you are the fresher, that once you are appearing before the court, then you should be properly dressed up first. You should be reach on the time second. You should go to the file. You should prepare the file in the very short and sweet manner. You should have a brief note. And once you are addressing to the court, and certainly you should say, my lord or your ladyship. If it is a lady, then your ladyship. Yes, if the gents, then my lord. And you should address like that. And whatever you want to say, you can say in the brief. Because what are the contents? Contents may be the different matters, may be the different issue, may be the different facts, may be the different. So whatever your facts, you should be prepared thoroughly. You should not start turning up the page once you are appearing.
Sometimes may have a client with us, and sometimes the judges raise the question,
Yes.
but if I am not aware about that the fact, and if with us the client, and client more aware about the fact, so whether we should give the chance to the client to spoke in front of the judges?
No, I will never suggest. I will never suggest only because of that. Once you are not aware from the fact and the client is aware from the fact, then once your client will start speaking, then it is always give a bad impression of your professional career, because the client think that you are not very much aware, you are not competent person, you are not able to address the argument. I did my argument before the court and court pass an order in my favor. Then what is your relevancy, my learned friend? You are appearing and you are charging something. You are taking your professional fee.
Yes,
Only because of that you are appearing on behalf of your client. Once you are not addressing to the argument and your client is able to address the argument, why your client will hire you? Why they will pay fee you?
right, sir.
You should be more competent than your client, because client can only give you the updates, give you the facts, but how to represent the matter, you are very well aware. And only people who are paying only because of you, that you are very well aware from this fact, you are 100% very wonderful presentation before the court, and certainly your client is expecting that you will get a good relief from the court. Only because of that client is hiring you. So you should not give an opportunity to the client. And once you are not very well aware from the fact, certainly ask to the court, my lord, kindly give me some time, and I will come prepared and I will address the argument and assist to the honorable court. You should never say that,
Right,
yes, client, you should address the argument. No, you should take time, and certainly being a fresher, always the honorable judges appreciate to, yes, fresher can argue the matter. Always appreciable.
right, sir.
And you should take time,
But,
not say your client to argue. And 100% time will be
but
taken.
sometimes we are facing the problem. Questions, and so so, uh, from our client side, like if I am getting the first time case, and then what type of the I should information gathering the
Even though you are taking the case first time, of course, everyone getting the first time case once he started practice. So it may be possible that you may be undergone training with your senior or somewhere. Then you should be aware about the fact, because it is entirely the case where you have to represent.
Hello?
You are aware from the fact. And what is the fact? You can address the court, say to the court
No.
with a dignified.
Sir, my question is that what are areas we should cover while gathering the information from the clients, and what should we keep in mind while getting the information from the client, sir?
Yes, yes. Very good question. The first of all, you have to look into what is the jurisdiction of the court. That is very most important. Once you are taking the case, you have to look into what is the jurisdiction of the case. Means, suppose if the offense is committed in Calcutta and you are filing the case in Delhi, your client approach you and you are filing the case in Delhi, it's never been happened. So first of all, you have to look into that where is the jurisdiction and what are the contents of those cases. If it is a civil nature case, then you have to look into the agreement, there is an arbitration clause or not. Once there is an arbitration clause, then you cannot approach to the civil court. Then you have to invoke the arbitration.
Right.
It depends upon the case-to-case basis.
Right, sir.
Suppose if anything happens in Delhi, means any crime has been committed in Delhi, then even though you are based in the Bengal, but once the crime is committed in Delhi, then you have to recourse at Delhi itself, irrespective of your residence. So these have to stick in the mind that before going to the court, you have to look into what is the jurisdiction, what is the pecuniary jurisdiction, and who is the competent judge to hear this matter. It may be go to the High Court, or maybe go to the Supreme Court, or maybe go to the District Court. You have to, because in the Delhi there are the monetary jurisdictions. That once it is 2 crores, then go to the District Court. More than 2 crores, then go to the High Court. Then you have to look into all those aspects.
Right, sir.
Yes.
Thank you, sir.
Most welcome. Any other question, please? Probably there is no question. Then I would like to announce as well that every month, second and fourth Saturday, we will keep on touch with you with the different topics. And on 25th of this month, 25th February, we will going to have a session on the drafting skills. How to draft the matter.
Timing will be the same, sir?
If all will agree, the timing will be same. If it is comfortable to all of you.
Okay. Right, sir.
Probably in the Saturday, most of the people are free.
Right.
Otherwise, you can also take a session in the evening hours, because everyone is free and fresh very early in the morning. So I decided this time only, and only on the Saturday, only because of second Saturday is always holiday for the court, and High Court and Supreme Court, all the Saturdays are off. Most of the offices are also off on the Saturday. for the corporate lawyers as well. So 25th February.
So, yeah. So can you make any group like this so that you can put any information on that group? Accordingly, we
Yes.
can inform you.
Yes, we have created a group of Vidya Vijay Foundation. This is the NGO through which we are doing the same.
Right.
And you can, if you note down my WhatsApp number 9999, I will drop in the chat box. 9999 130
130
332.
332. Right, sir. Thank you.
I will also drop in the chat box.
Yes.
9999 130 332.
Right, sir. Thank you, sir.
This is my WhatsApp number, and you can WhatsApp me. Certainly, you will add in the group, and we will keep on taking this session.
Okay, sir. Thank you.
Thank you. Is there any question from anyone? Yes, Mr. Ritesh. Ritesh.
I think we can conclude this session.
Yes,
If there are any more questions, the same may please be asked. Okay. Thank you, sir. Thank you for sharing your valuable knowledge over the subject and teaching our audience the way they should appear before courts. I'm sure that with the knowledge we have gained from this session, we will surely improve our court appearance. I would also like to thank our audience for their active participation and involvement. And we are looking forward for your active participation in all our coming sessions and expecting more response from our colleague members in such an informative session. Thank you, everyone. Thank you.
Thank you. Thank you for presenting.
Thank you, Nitya sir,
Thank
for
you.
enhancing the
Thank
knowledge.
you.
Thank you.